Good evening, everyone. My name is Virginia Harder. I'm the chairperson of Chelsea Planning and Zoning Commission. Today is Wednesday, October 16th. The commission being conducted.
I can't hear anything on Zoom. Nothing. I hear nothing.
Back.
Okay. Try it again. Can you hear us?
Matt, can you hear this?
Much better, much better. Thank you.
Okay, very good. Then I'll start over. Good evening, everyone. My name is Virginia Harder. I'm the chair of Shelton Planning and Zoning Commission. Today's Wednesday, October 16th, 2024, on the special meeting of the commission being conducted in room 104, Shelton City Hall, and via Zoom is hereby called to order at 5:05 p.m. This meeting is also being carried live on YouTube. Would everyone please rise for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I got a text message that someone remote still can't hear, but hopefully.
Well, if Matt can hear that.
Yeah.
It's not.
Let me just say, refresh your screen. Okay, in any event, I'll start off the roll call of the commission. Please verbally indicate when your name is called. Commissioner Kelly?
Present.
Commissioner Parkins?
Present.
Commissioner Maddow?
Here.
Alternate Commissioner McGee?
Here.
Myself, Commissioner Harder. Ms. Castro, our Assistant Administrator.
Present.
Attorney Francis Teodosi, our Corporation Counsel.
Present.
Ms. Vernassos, our Recording Secretary.
Present.
Thank you. And we do not need the services of our stenographer right now. Commissioner Cristiano is on his way. For the record, Commissioner Tiggy is unable to attend this meeting. Alternate Commissioner McGee, you are being seated for Commissioner Tiggy. Please acknowledge that you understand that.
I understand.
Very good. A couple of points. Before continuing with this evening's agenda, Ms. Castro will act as a Zoom meeting host. And while commissioners will be able to make comments throughout the meeting, the chair asks you please identify yourself and wait to be recognized before speaking to make sure we are not all speaking over each other and to make sure our recording secretary is clear as to who is speaking. First agenda item is acknowledgement of the appointment by the Planning and Zoning Commissioners, regular Republican members of Win Apple as the Republican alternate. Congratulations. Welcome to the commission. We look forward to working with you. Second is a zoning law review with Attorney Francis Teodosi, the city's corporation counsel. Attorney Teodosi, you have the floor.
All right, thank you. What I'd like to do tonight is really threefold. I've attended a lot of your meetings since I've become corporation counsel. But I don't attend the majority of them. And I've observed some, I'm going to say, collective positions on the part of the Planning and Zoning Commission, which I understand that you have been set in your ways to take. Have any of you gone to the Planning and Zoning Commission? And I don't mean this in any really critical way. I just want to know because it'll gauge how much I explain. The seminars that are put on by the state of Connecticut.
Charlie and I have gone to the ones by the American Bar Association, Connecticut. All of us had to attend ones as required by the state for the new state statute. Those are
one all day,
Mhm.
it was all day.
Mm-hmm.
Did any of those have any emphasis in 8-3G?
No.
Not emphasis, the ones up in from the Bar Association has a binder with, it's gotta be 24 different topics at least. And there is A30Gs in there, but everything is like a 20-minute talk, and that's it, and you,
You was talking about the one that.
yeah, Wesleyan, we went to
Yeah,
one,
Wesleyan.
then it was next time was remote.
Yeah, that was, right, it's about 20 minutes.
We had that guy from the state, to
Mhm.
one of our meetings.
Yeah.
Mhm.
Yeah, I was there. for that.
Oh.
Yeah.
It wasn't that helpful.
No, they
But
just-
since we're talking about 8-30G, on Thursday night, and I don't know whether it is put in place as a settlement, if it's a public service activity or requested by one of the local boards, but in Oxford, there's going to be an 8-30G presentation being put on by VCOG,
Mhm.
the local planning group that covers Oxford and actually covers us. I don't know if you need to get a ticket. I don't know if it's limited. I just came across the information last night, so I thought it'd be relevant to tell you that.
Yeah, I received it last week, but unfortunately I've got another commitment. I'll be in New York.
I don't even remember getting anything myself.
This evening?
No, tomorrow night.
It could just be because I'm.
We're talking about tomorrow night.
Tomorrow night.
Yeah.
I think if you contact VCOG or go on VCOG's website, you might
Mm-hmm,
find out, or go on Oxford's.
mm-hmm.
But I saw it and I wanted to mention it just in case. Maybe you could zoom in.
Mhm.
There was one that I sent about 2 or 3 weeks ago that's gonna be virtual, hosted by ValleyCog on the 22nd, I believe, at like 10 AM, so I sent everyone a link. To
Is that
register.
being operated out of Oxford?
No,
Okay.
It's at,
Eleven.
it's at 11 o'clock on the 22nd.
The Oxford,
Webinar.
the
That's
Oxford.
not the one, the one that Andy
The
just.
cog,
Okay.
and the cog.
All right,
Okay.
so before we start, because I have attended some meetings, but not a lot of meetings, and we went through COVID together. Just want to explain to you my background. I've been the corporation counsel for the city of Derby going way back to 1984. I was a corporation counsel in Derby for 3 terms. I was also counsel with John Welch in Orange for 1 term. Counsel in Ansonia for 3 terms. Counsel in Oxford for 2 terms. Counsel in Seymour for 1 term. And in all those communities, excepting Seymour, we dealt with planning and zoning issues, and I counseled planning and zoning commissions. Not exclusively, other members of our office did also. And in Orange particularly, John was the lead party. But the point I'm trying to make is I have a historic perspective on what planning and zoning commissions do. And I think I know pretty well what the law is with regard to planning and zoning commissions, and especially how it's changing. And that's what the purpose of this discussion is tonight. Planning and zoning commissions historically, and outside the context of an 8-30G, still enjoy a good position with the Superior Court. There are a number of premises that the Superior Court uses with regard to normal zoning matters that benefit the Planning and Zoning Commission. If an appeal is taken by somebody that's challenging something outside of planning and zoning's 8-30G responsibilities, pretty much 90% of the time, the applicant has the burden of showing that Planning and Zoning Commission did something wrong. There has to be evidence in the record, but on all the jump balls, the Planning and Zoning Commission gets the benefit of the doubt. That's not the case in 8-30G. And 8-30G has worked its way into the zoning regulations in various ways by directives from the chief executives of the state, by the Superior Court cases, the appellate court cases, and the Supreme Court cases, and by the legislation itself, 8-30G. It's styled pretty much after a form that was used in New Jersey and Massachusetts. And you know full well its primary mode of operation, and that is to incentivize developers to make N-30G applications, and because they do that, they are entitled to a different set of presumptions with regard to how the approval process goes. Now, a second ago, I said that all jump balls go to the Planning and Zoning Commission. It's the exact opposite. If you'll allow me to use that metaphor, in 8-30G applications. And that is primarily because the law says that they're going to presume that there is a necessity for this type of housing. And unless you collectively, as the Planning and Zoning Commission, can justify it's necessary to protect substantial interests in health, safety, or other matters that the commission can legally consider, the applicant is going to be successful with an appeal. So we go into the 8-30G appeals with the judge not reading the record to find something to back up the Planning and Zoning Commission, but to essentially find something from the Planning and Zoning Commission that justifies that protection of the health and welfare of the citizenship. And it cannot be speculation. The court just won't stand for that. And in a number of cases, and some of these buzzwords you're going to recognize from your own hearings, okay? And I just highlighted a couple of them. The ratio of parking spaces. Unless you can show a substantial health risk for abandoning those parking ratios, court isn't going to give too much for not abandoning those ratios. The court isn't going to give too much credence to your position. Secondary access roads that are not there, unless there's a fire code that says it absolutely has to be there. If the commission just thinks that there should be a secondary access and there's no public health reason for that protection of health, the court would stop that then. No
Excuse me,
sidewalks.
Attorney Tito, I just want to confirm for the record that Commissioner Cristiano joined us at 5:16 PM.
Welcome.
Thank you.
We're just going over some of the ideas that are raised in 8-30G applications that the courts have looked at and said, yeah, okay, but show us how your position on that protects the health and safety of the populace. And one of them is secondary access roads, which I just mentioned, ratio of parking spaces, not enough sidewalks, fire lanes being too narrow. Even the justification for a denial because the applicant is invading the industrial base of the town can be called into question if that industrial base hasn't been kept totally vanilla. You have to explain to the court why you are differentiating if you've allowed it in one part of the town.
I didn't pick up the first word you said.
Industrial.
No, evading, something evading, rating.
Yeah, I didn't quite
That,
I can't remember. what
Okay.
it said.
something about the industrial zone,
Invading the industrial. zone.
invading, okay,
Okay,
yep,
even if you're rejecting planning and zoning application because you say that this is an industrial area and we're protecting our industrial area, you know, that's one of the ways that you can protect it from 8-30G. If you have had an invasion
Mhm.
of that zone with another type of housing, then you're gonna be hard pressed to just say, oh, we're keeping our industrial zone pristine.
Mhm.
The court's going to say, okay, you allowed it over there, or you did it over there, give us the health and welfare position that you're taking with regard to why it shouldn't be here. If the courts are just they're not picking on you. They're zeroing in on what the 8-30G legislation says. And my purpose in having this discussion with you, number one, to explain to you that the change has been made over the 20 years. I see it through all those towns that I've been representing. And to explain to you what the measuring stick is that the court is using, that I always forget the jargon.
Here's how many get put in the judge's time.
To necessarily protect the substantial interests in the health and safety of members of the city. Now, you know the game has changed. You know what the court needs you to show. You can't show it by saying, I think that road is too narrow. You can't show it by saying, I think those parking space ratios are incorrect for us because our regulations say this. You can't say that secondary access road is really needed for safety purposes. I want it there. You can't say, if you don't have sidewalks, I'm not approving it because it's a safety hazard. Okay, now you've all said that sometime. The point I'm trying to make is you need to have an affirmative record to back that up. That is surmise and conjecture. The court, in the court's game, is looking for a record. We always bring the record up. The record used to protect you. The record doesn't protect you anymore if you're taking that kind of posture with 8-30G applications and you don't have the evidence in the file. To give you a perfect example, Fairfield. Fairfield has a citizens group, okay? Fairfield has a citizens group that goes into planning and zoning commission meetings and advocates for the health and welfare of the community, bringing in certain experts to fight, or I shouldn't say fight, but put on an alternative position. So then the planning and zoning commission can rely upon that. Even with that kind of firepower, you're all pretty adept at news. Fairfield has lost its last two cases for 8-30G applications. I'm going to get into specifically why they lost, because I think some of the decisions are germane to stuff that you have in front of you. But the point I'm making is if cases fall the other way with a record of a type that Fairfield could build, and the court is still looking at the applications and saying, we don't think you've satisfied your burden, you got a tough uphill battle to deny 8-30Gs. And look, I know that it gets under your skin to even be discussing 8-30Gs, but that's the law. That's what the law is. And in court, the court is going to enforce the law, and it's my job to tell you what the law is. And I thought by explaining the history of my own activity with planning and zoning commissions and specific examples of what I've heard on various cases with regard to your contact with 8-30G and decisions, and then going to some of the case law, that we could get a consensus as to what you want to do with an 8-30G application. Because I remain convinced that the best way to deal with an 8-30G application, or even the threat of an 8-30G application, is to make your decisions here at the Planning and Zoning Commission and not leave them to the whim of a spin of the bottle at the Superior Court, especially when you're going into that kind of context. Going back 20 years, bringing it up to the court, jump ball in your favor, it just doesn't happen anymore. And it's happening less and less when you have cities like Fairfield and Newtown taking appeals. And those are No, let's face it, those are communities that are very protective of all of their neighborhoods and very protective of the kind of style of homes that they have and what they want in their community. And they're losing 8-30G applications. And I do not mean to imply that an 8-30G application in any way is going to diminish the value of homes next to them. It's an alternative kind of housing. It's a kind of housing that, quite honestly, I was never a fan of, but I recognize what is happening. So,
Could you give us some examples of what would be considered a health and safety issue that would hold up in court? Like, it doesn't sound like there are any.
well, certain,
If there's no sewer.
yeah, sewer, if there's no sewer, you're not obligated to extend the sewer up.
It's not much.
You know.
The accessory road, that would hold up if it were a fire.
I'm sorry,
The accessory road kind of thing would hold up if it were determined by the fire.
if the fire regulations said it, but just to say it's too narrow is not enough. In that case, and there was even evidence in the record that the roadway was narrow, but it was wide enough to accommodate a fire truck. But the commission just said it's too narrow and it's dangerous, and the court said, hey, your own truck can go over it. And all right, so let me switch to the Fairfield cases specifically, two of them, and one of the Newtown cases, because I do think that they're relevant with regard to everything that you've got in front of you or pending right now. I also don't remember what particular case it is, but it was submitted to you with the application that involved.
Beach Road, 131 Beach Road.
No, the application that involved Hawks Ridge, when, not Hawks Ridge, but the Hawks Ridge people came to the,
Oh, for the Long Hill Crossroad.
right, right.
application.
One of the cases that was sent to you, with regard to that, the judge made the following finding, that if your zoning regulation provide for a certain traffic pattern and a certain layout of parking and everything, it is presumed that your roads are adequate for full development of that area. So even saying, well, you know, we have all this congestion here and our plan of development does say that you can situate yourself over here, but that's really going to strain our roadways. Court says, look, if your plan of development says that that property can be developed, or you have a plan of development that allows PDVs to come down in certain areas, that is presumed, those areas are presumed to have sufficient and adequate traffic flow patterns, and you cannot just say you can't do that. Again, you gotta bring in your own people, and even bringing in your own people, you've got to show that there's something tremendously wrong with regard to what the city has already approved for a traffic configuration with an area that could be developed as densely as the plan of development allows. Okay? All right. Fairfield, the Fairfield case, in full disclosure here, the Fairfield case pertains to a case that I have a conflict with. It's the matter of Scheibel. The Scheibel family have historically been clients of our office. Our office goes back in Shelton approximately 40 years. So as Scheibel is taken up on appeal, I cannot be representing the city, and I will refer that out to another attorney, as is my responsibility and authority under the charter. But I want to explain with that full disclosure what the Fairfield case says and how it's relevant to Scheibel. And if you want to talk about Scheibel, I will talk about it with my disclaimer already, so. All right, that case involved two circumstances or 2 points. There was a petition to change a zone. And there was a petition to get an 8-30G application in. First, the easier part, if you will. The court considers an the court considers an application to change a zone to be an application under 8-30G. Now, we're gonna see if anybody was listening. What does that do to the application?
Changes all the requirements.
It flips them. Okay? An application to change a zone normally gives you a tremendous amount of discretion. An application to change a zone of 8-30G, the court says, 8-30G talks about applications, court puts it in quotes, and then concludes that therefore, an application to change a zone gets the same kind of preferential treatment under those switch of burdens that the actual 8-30G application does. So what does that do? That again puts the onus on you to determine why the health and safety of the community is threatened by this change. And that's not property values, that's not, I don't like the way it looks, that's not density unless you can, number one, get that kind of information on the record from experts, i.e. like a Fairfield Community Group. And number two, show that somehow it affects the health and safety. And therefore you're gonna deny it. So Fairfield becomes a very powerful case for that. Now, the applicant won on that. The applicant lost on a second point. As part of the application, the applicant petitioned to change effectively an entire R1 zone to allow 8-30G applications. And the court said, you don't do it that way. You just apply for the specific location. And therefore, it allowed the rejection of the change of the entire R1 zone, if you will. Now, why are those relevant to the case that you have before you with regard to Scheibel? Because Scheibel has come in and Scheibel has asked for two things. It's asked for an 8-30G application, just like Fairfield. And it also asked for a particular zone to be changed. Now, the proponent of that case has a different opinion than me as to how it applies to our zone. However, I will say that after thinking about it for a while, when I first thought about it, I said, changing the zone underneath our PDD regulation, or changing the language under our PDD regulation, changes it for the entire town, and it can bring down a PDD, therefore you could bring down a PDD application anywhere. And that's not what the planning, or that's not what the Fairfield court said. The court said it should be surgical, it's specific to a zone. So
Specific to a piece of property.
right, I'm sorry. So my default was to say, okay, when you make a PDD application, just change the zone where you're doing the PDD. But when I started thinking about the case I brought up earlier, where the court now said that an application is considered to be an 8-30G when you're asking to change a zone, that would effectively gut the discretion you have with regard to PDD consideration. If you have the zone change be part of the PDD application. Remember, it's a twofold application. You petition to change the zone to put the PDD in there. my default in the reading of Fairfield at first was, okay, then let's not do it in our PDD regulation. Let's just say when you use the PDD regulation, if you're applying for 8-30G, put it in your 8-30G application. But that is going to load the deck against you. So in retrospect, I think that the way that it has been proposed to you is the better way to do it. Because there is a limitation there with regard to what the acreage is needed in order to utilize that language. And really what it would do is just allow PDDs that are that big. Now, you may have to deal with a PDD application that comes in demanding to change the zone anyway, because of what the court said about an application for a PDD being an 8-30G. But you don't have to set yourself up to fail by doing what I was thinking at first would have been the best way to do it. I actually think the way it came in is a better way to do
But I
it.
guess what was confusing to us is that the way the 830G law is written, the legislature put in there that you can submit a zone change with an application, but it's not necessarily needed. So if the 830G preempts all your local zoning laws, why would such a zone change be required under an 830G? Why wouldn't they just come in with an 830G?
Because the court said that authorization language that can submit a PDD, that's to enable you to use 8-30G zones where you don't think it would be allowed. And that's what the court was referencing when it said, if you petition to change the zone, it's going to be considered an 8-30G application. You don't have to in some cases because it's allowed because of the density and whatever. But if you got to change a zone, you can do
Well,
it.
they wouldn't be filing an 830G if the area allowed them to do a PDD, they'd get what they want that way. So they just threaten, if you don't give us the PDD, then we're gonna come back in with an 830G. So it's just used a threatening. It's a threatening mechanism. I'm sorry, you don't even need to respond.
I'm
It is
frankly lost, all right, so I've gotta say, I'm lost. I don't even know where I'm lost, so you'd have to start from the beginning.
And that's where you were confused. Why doesn't the 830G just trump? Why do they have to apply for a PDD to put the 830G in
Yeah,
there? That was
why we
lame.
have to grant a PDD, I don't get it.
Right, if they can
I'm
come
just
in and
like-
do the 830G there anyway, why do we need to grant a PDD?
All I'm saying to you is right now, the way that the court system is set up, you petition for a zone change and you petition for the PDD so that it fits into the club of the zoning regulations. But the court has said you don't do it for the entire area, you just do it for the specific location. In the context of your zoning regulations, you have your PDD regulation that essentially says where a PDD can be put down.
Mhm.
Right, requirements, yeah,
What's that?
right, it's a discretionary zone.
Right. So right now, somebody coming in has to change the zone. They're going to change the zone by an application through the PDD, and they'll try to guide you through. Let's say that the Scheibel petition to change our PDD language is limited. All right? An application comes in for a PDD. Right now, the way the case law stands, that PDD, and the key word is application for an 8-30G, gets treated with the same preferential treatment that any 8-30G application.
I think we kind of get that part.
Okay, so what is it?
I don't get what the whole PDD has to do with it, I'm sorry, and maybe it doesn't matter. Uh. Yeah, I don't know. So. Because that particular zone was what, was an R3? And they already met the density allowed on that piece of property. The only way, you're saying the only way they could increase that density is if we change it to a PDD or grant it a PDD change
Or end this
on
one?
a 30G application. Why wouldn't any 30G application just fit the bill anyway?
The way I understand Scheibel to have come in was they wanted to change the zone.
Right.
They petitioned you to change the zone.
Not initially, they
Yeah.
changed, they came in for a special exception.
Yeah, but
No.
then they
The
were,
lower
Right.
level.
Yeah, I
Yeah.
mean, the initial project.
right,
Right,
Yeah,
Right, but I'm not talking about the previous project. I'm
Right.
talking about the two applications you have in front of you right
yeah,
now.
okay,
They came in for a zone change. And they came in for an 8-30G
yeah,
there. Okay? So take that to the two premises that come out of Fairfield. Number one, if you have an application for an 8-30G, anything within that application that asks for a zone change is going to be considered as part of the 8-30G application and given the benefit of the doubt, so I don't have to repeat everything. Okay? I read that case and I looked at Scheibel and I said, let's not change our PDD regulations. Let's just understand when the PDD application comes in, that it's got this benefit of the doubt, this special preference. But I think that hurts you if you look at it that way, because then you're opening the floodgates. You're essentially setting a precedent that anybody can come in with a PDD, your zoning regulations be damned. And that's what's happening slowly.
Mhm.
But what I'm saying to you is the way that it's petitioned is better for you than the way that I just explained we could take the application and be consistent with the Fairfield case.
Cause I did actually read this entire
Mhm.
thing, and in here on page 12, it says that. This was the Wisanowski versus the Planning Commission. No formal zone change application is needed because 830G is designed to allow circumvention of the usual exhaustion of zoning remedies and to provide prompt judicial review of a denial of an application. Embodied in the application for an affordable housing subdivision is a zone change. Thus, although the plaintiff was not required to file an application for a zone text amendment to build an affordable housing development, it nonetheless statutorily was entitled to seek a change in the zoning regulations governing the subject property and to have the application considered by the zoning commission under the standards. So
Mhm.
that's basically saying that it's kind of baked into the law.
That's what I'm trying to say. Maybe
That's-
I'm being not being
No, I think-
eloquent enough, but.
definitely not.
You're a tough crowd.
So this is plain English that says no zone change is needed because it's already baked in.
But
to
what I'm
the
trying to say to
legislature.
you is, if you do what Scheibel says. Right.
If
If
we
you
do
as a
what
commission,
Scheibel's-
if you as a commission don't wanna do a zone change, you're gonna take Scheibel as an application for a PDD that is an 8-30G. And they're gonna just ask for the.
The question remains, why does it need to be changed to a PDD? Why can't they just put in an affordable housing for whatever they wanna do there? Why does it need a PDD?
And I'd like to bring up the point you were making about this whole project. If he had come in initially with this piece of land with an 830G application, we would get a much larger number of affordable units.
larger number of units.
No, but like say he's gonna end up with 40 units or whatever the number is, and we would then have been able to get 30% of those as affordable. So what he's proposing is if we get none on the first half,
We've already proved that.
right? But can't we say we want, you know, I mean, if we're stuck with this 830G, it sounds like we are. Can't we say we want the percentage to apply to the entire piece?
Understanding that I am historically the attorney for Scheibel,
Yeah,
I don't think you can do that because you've already got one application there.
Well, then you can't make the entire parcel part of the PDD then.
he needs to subdivide it, does he not?
Subdivide it and just make the new part of it the PDD. It shouldn't apply to the entire parcel. So and that's a strategy. That's not part of this discussion, so.
No, but I think it would be a cleaner.
Oh, I agree. I agree.
Okay, but
And
the
But
only,
that's putting him into a situation because he.
Yeah,
he can't
understood.
comment on
the only
But-
reason I brought it up is to try to reconcile it with the Fairfield case stuff.
I think we're understanding the concept, but we're not on the same page to get there. Because what I just read basically says you don't need a zone change to put in an affordable housing. So why does this application need a zone change to put in the affordable housing? That's where a lot of the confusion came in when
Okay.
the attorney was talking in circles around us.
Well, he can apply for a PDD
Mhm.
with the 8-30G in it. And ask for a zone change in the PDD if the density is not something that is allowed there. That's what the Fairfield case says.
Why doesn't that just go, why isn't that just irrelevant
Yeah.
with an 830G? The fact that the density isn't allowed there, why isn't that just irrelevant?
It's irrelevant if you make it irrelevant.
No, I mean, 830G seems to me.
830G
If you're
is
accepting
making
the
it-
premise that a PDD can come in as an 8-30G application, period. And you want to do that, okay, all I was trying to say to you is if you keep it as something that's essentially an administrative action in going to the regulation for our PDDs and saying, okay, the language that was written for Scheibel, I'm going to take off and I'm going to apply for a PDD with regard to this particular piece of property because I have this much acreage. That's something that you as a commission can differentiate other applications by using it.
So what,
If you accept the premise that you're explaining there, which is essentially the same way I took the case the first time I read it. But when I thought about it more, I said, do we really want to do this? Does the commission want to go down the road of saying, okay, we get it. We know what the courts are saying. You do a PDD application. If it's a PDD to throw an 8-30G in here, then the PDD application itself gets to be treated like an affordable housing case. And therefore, all the text that is written up for the PDD is essentially modified by, rather than the applicant having to do things, you having to.
I won't speak for any other commissioner, but I am not inclined to have our PDD become bastardized through the 830G process. That's as clear as I can put it.
Okay,
If they want to build affordable housing, let them come in and build affordable housing, right? We know what we're up against with that. But now they're trying to use the affordable housing to get PDDs. And that,
Well, affordable housing is not a zone change.
they're not
Right.
doing it.
It's not.
They're not doing it. The court has just said that 8-30G application that changes a zone is to be considered an application in the 8-30G.
And it cannot be denied.
Not that it can't be denied, but that you're gonna be up against the.
The reasons for denial would have to be so
So,
tight that
correct.
the judge would say.
So how do we keep our PDD out of this situation? Is my question.
That's what I'm trying to say, and you guys are disagreeing with me. If you
We're
take,
just not understanding you. It's
if you
speaking for
take the
myself.
writing, you know what, you close the public hearing on the portion of the application that asks to modify your PDD regulation. It asks to modify that PDD regulation so that in order to get the PDD, you didn't apply for a PDD in a specific zone change. You just came over to your PDD regulations, said, I have sufficient acreage here. Okay, you can allow me to do this. So that the next application that comes in, if they have the sufficient acreage, they can do it. But if they come in and they say, I wanna do an 8-30G as a PDD, they're bastardizing your regulation, which you just said you didn't want. So I'm trying to say to you, my initial thought, your initial thought, carried to its ultimate conclusion, does bastardize the PDD. And you might have better luck if you consider the text change for the PDD as the way that this particular PDD is considered.
But we have two separate applications for this.
That's, you
Yeah.
have two separate applications because that's what Fairfield was
Yeah,
showing.
so how do we deal with one and not the other? How do we?
Well, they filed it as one. They filed it in connection to. Or in connection with.
I'm talking about 2417 and 2416. One is to change section 34.1. And one is to get
That's not-
approval for 20 townhouses and 21 bedroom units.
Okay, you closed the public hearing for.
The text.
24.
text change.
Yes,
So. To answer your question, how do you do it? You approve the text change and then you consider the application.
Mhm.
But the text change is just applies to this PDD only.
It applies to any application that could go to the PDD regulation and have that particular
Which
characteristic.
would basically be any PDD,
Right, exactly.
No,
any PDD.
I don't think it is. What is the language? What's your language say?
Language just said, by, if the properties are surrounded by residential, that was the whole purpose of filing the text change, nothing more than that. Because in the prior case,
Which means what?
prior application, the rejection had been because one of them had been because the property was totally surrounded by residential. So the only reason it did was just to open the door in that way. If you filed it and there was no sewers, you'd still be denied because I left that in. And there are sewers.
It's for you guys to decide. I'm just telling you, I think that that's a better way than the other way. The other way bastardizes your regulations. It's up to you guys.
Yeah.
Okay,
Hope the public's listening to this, that's all I can say.
is that,
I said, I hope the public is listening to this, that's all I can say.
What we are concerned about is that something like this is approved. And then later on, it's a gotcha.
They're gonna do it all over.
They're gonna do it all over anyway.
that's what I'm trying
Right.
to tell you.
You're right.
Yeah. They don't even need this change. Still don't know why they want this change. Still, I
But-
still don't get it, but I get the 830G part of it, I think, pretty well.
I actually think your PDD regulation is something very good and gives you a lot of discretion
It has been very.
Not the same discretion that you had 20 years ago, but still a lot of discretion. And I would hate to have a couple of cases come out of Shelton that officially bless bastardizing the PDD, because then you'd be stuck with it.
We're losing that discretion though. Fran, we're losing that discretion. It's being forced upon us.
Okay, but why do you want to send soldiers into battle that are gonna get shot down? Why don't you try to pitch a couple of battles here? Understanding that you're not as protected as you used to be by the appeal process. 20 years ago, Planning and Zoning Commission was in a much stronger position before the Superior Court than they are now.
So if we have an application comes in, I was told a long time ago, approve what you're comfortable with. So if we were to say, okay, we have an application, they're asking for X number of units, but I would propose that we would be only comfortable with 75%.
I mean, you
Are
can
we-
do that, but it's subject to discussion and negotiation again, because if you approve that way and you don't, and you theoretically reject the others. There's nothing in the record
Mhm.
that says why you rejected
Mhm.
the others.
Mhm.
Unless the applicant is willing to take what you've provided, because there's
Mhm.
been a give and take. You're gonna lose on appeal, because you've got
Right.
nothing in the record.
And there's also the case that they'll argue that it's by reducing the count, it's not financially viable project.
Mhm.
Well, they don't even have to do that. They
We'll
say,
lose
we
on that.
applied for this, they didn't show any public health reason, and they rejected it effectively because they approved this much.
Mhm.
Can we technically ask for more? Tell them we want a larger.
Higher
project?
percentage.
Higher percentage of units
But-
or
but-
830G?
What do you
Units.
have to prove?
I don't know, you tell me, what do we have?
I didn't, you had to prove that it's better for the health and welfare of the community.
To have more units.
Or in this case, by adding the entire PDD into it. An additional 12 units. How would the state find that?
You're gonna need experts.
But it's not on the.
Well, it's not a matter of finding experts to prove that
It's a
it's.
matter of finding experts. The court said,
We don't meet the requirement of the affordable housing, so any additional increase would be needed. That's a plain and simple fact. We need
plain and
more,
simple facts found by the Planning and Zoning
we
Commission
need more,
are rejected by
Give
the
us more.
Superior Court
give us more,
without.
This is the percentage on the whole project.
yeah,
I just wonder how those homeowners, I mean, you think homeowners,
I would be livid,
I just,
I would be livid.
Okay,
of course.
full disclosure, I told you that
Yep.
every one of those applicants had it in their deed and in their, public offering statement. They all know about it. It's their.
No,
it's
they-
public.
They didn't know that there was gonna be an affordable housing component to that project. That's not true, Fran.
Or.
No, I didn't say that.
What are you talking about? Fairfield?
No,
No,
Daybird.
yeah, they,
Oh, no, they didn't know that.
The public record discloses that there's going to be access through that roadway for another project.
not for affordable housing.
I
Not
didn't
for
say
the
what-
initial project,
What?
not for the initial project, the whole decision there was that they had used their density on that.
There is a
property.
clause in all condos until it's turned over to the homeowners association. There is always a clause that it's an expandable community and can be expanded.
Mm.
Doesn't mean it's
As a
going
condo
to, but it can
project,
be, yes.
but-
But that's not what this language said. This language said that the roadways could be used to access another development. That there was going to be another development. Didn't talk anything about the specific type of application. It talked about the use of the road.
So their understanding, we presume, they understood that that piece of property had been totally developed based on the zone that existed that we worked with them on. It's kind of let the buyer beware, like,
That's about it.
yeah, so you're saying too bad for them because. They may have bought, they're assuming that it was a done project
Mhm.
based on what we had originally approved. Which was the total density allowed for that particular piece of property. We screwed up by not requiring that the remainder of that property be designated as open space.
We couldn't do that as a
We
special
couldn't?
exception.
No,
No,
couldn't have been protected in any
we
way.
couldn't demand that they have, you turn over half their property
Well,
as open
I mean, they
space for
implied that that's
approval of a
what,
special
that-
exception.
it was implied that
He's
that's
got to
what was
adjourn.
happening there.
About 5:59.
Hmm.
Yeah, it's unfortunate with this conflict of interest, so.
Okay, so, we have come to a point where we have to adjourn because we have to get to our, 6 p.m. meeting. So thank you, Attorney Zito, so continue this
Okay,
at some
well,
point.
once you guys have specific questions, we're gonna go into executive session.
First, yeah.
Yeah.
No, no, no.